Welcome to the Heartbreak to Happiness Show with Sara Davison. If you're struggling with a breakup and you feel shocked, angry, betrayed, devastated, or sad and alone, then this podcast is for you. Best-selling author and award-winning host Sara Davison shares how you too can get on with your life to heal, grow, and move from heartbreak to happiness. Here's your host, Sara Davison.
Welcome back to the show, and today my guest is Joseph Willmore. Joseph helps people not to get screwed when getting a divorce. He started his practice after realizing that most divorce attorneys, or lawyers as we call them here in the UK, have a bad rap because they profit from a long, drawn-out fight. Joseph focuses on helping his clients get the best outcome by positioning them in the most positive light. Now, his unique style has won over every judge, and he has never lost a case in 10 years, serving hundreds of clients from stay-at-home mums to athletes, business moguls, and celebrities. So I am super excited to welcome Joseph Willmore to the show. Welcome, Joseph.
Hi, Sarah. Thank you for having me.
I'm really excited. My listeners are thinking, gosh, he's a very brave man coming on with Sara when she is so outspoken about family lawyers or attorneys. And you say over that. So thank you for coming on. And I'm really keen to find out more about you and the work you do. So do please put us in the picture of how did you get into family law, and tell us a bit about all the different clients that you work with.
Yes. So how I got into family law. I do not believe anybody goes to law school dreaming of being a divorce attorney or a family law attorney. I know that certainly was not me. I believe my dreams in law school was to be some prestigious criminal defense attorney trying big cases of that nature. And I graduated from law school, it was a difficult economic times. This was in 2011. So I ended up working in civil litigation at a big mega law firm, which technically is within the dream, so to speak, of graduating law school and getting that job. Hated it. So about a year after, I decided to go out on my own and become a solo practitioner. I made the typical mistakes a baby attorney makes when starting their own firm. And I said I'd do every practice of law. And of course, that included family. The first case I took when I started my own law firm was a divorce case. And that's kind of how I fell into it. And I realized I really liked it. And then about 6 months later, I had narrowed my practice into only taking family law matters. And here I am, 10 years of practice later, as a certified family law specialist here based out of San Diego, California.
Wow, that's a bit of a journey. So tell me, what kind of clients do you represent? Because I know you're well known for winning your cases. So tell us a bit about that.
Again, I'm based in San Diego, California. I have clients all throughout Southern California, so that expands from LA, Orange County, Riverside County, and San Diego County, primarily being San Diego County. And I represent a wide spectrum of people, from those considered to be celebrities, business owners. Here in San Diego, there's a lot of military service members, so military members as well, nurses, doctors, to housewives, and like I said, the full spectrum of people.
Okay, that's interesting, because in my opinion, nobody really wins in family court. I think a lot of my clients come to me thinking, oh, well, if I go to court, I'm going to get justice. That's one of the first myths that we tend to have to bust when we come through the doors, unfortunately.
Absolutely.
I usually see that sometimes you get a better outcome than, it could have gone one or two ways and you sort of went on the better side of it. But do you really feel that, you can win a case like that?
I think there never is an absolute clear winner and loser. when it comes to family law and when it comes to divorce in particular. Because if we look at the topic, which is a divorce, that's a loss to begin with, because I don't think anybody goes into a marriage with the expectation that it will fail. And the fact that it has is the loss in and of itself. So clients are coming to us in this extremely sensitive, emotional situation, oftentimes where one of the biggest struggles of my job is managing my clients' their expectations. And as you said, a lot of people come to family law expecting justice, and we have a legal system that is broken, judges that do not care about you. So issues that you may find very important and say, oh, the judge will really see this. Judges oftentimes won't see that. So as far as truly winning a case, I would say the win is getting the client in the best situation possible financially, the best situation possible with regard to their children, making sure that the children have a good custody schedule, considering the personal situation that the parties find themselves in, and the ability for the client to move on with their lives. Sometimes a client doesn't see that they won in the sense until several months after the fact, when their case has been done. They realize, okay, I really am in a better situation. And that's oftentimes when a client will reach back out to me and say, hey, thank you for that. I didn't see it a few months ago. I felt like I was not winning, but in the end, I won by getting my life back and getting in the situation that I am in today.
Yeah, and I mean, I think that's so true. And you said a couple of things there that I'd like to dive in on. You said that you think the legal system is broken. Tell me a bit more about where you see that system falling down.
The legal system is broken to the degree of the process is very difficult, of course, for a self-represented person to navigate it. I would say it's unnecessarily complicated to where there's, so for example, I'll oftentimes have people who have very simple matters, or they feel that they've resolved a number of issues between their spouses. But as far as a self-represented person trying to go to court to take care of it themselves, judgments are very complicated to get pushed through, especially here in California, to where a self-represented person will try to do that for, say, a period of a year, and then they'll come to me, and it's something, of course, for me, very simple to figure out and navigate, but there's simply no help with the court system as far as somebody being able to do that on their own. Now, with regard to child custody issues, that's a whole nother barrage of issues, because, for example, if we're talking issues of parental alienation, in California, that's a very difficult thing to prove. That could take perhaps even 2 years of investigations to get to a point to present that meaningfully to a judge. So if we look at, say, for example, the time period involved, 2 years with a child with regard to issues that require immediate attention, absolutely, that's a broken process, because that's, with 2 years for a child, that is tremendous. That is lost with between one of the parents, perhaps a parenting time, and 2 years of misery for a child in that situation as well, to not have a relationship or to have been coerced by one parent versus the other. So there's just a lot of...
There's another side to that, right, that I would point out. Now, I totally understand that parental alienation does happen, and that's, it's horrific for the child and the parents involved, or the parent that is alienated from their children. But that is in the minority compared to the number of people that are falsely accused of alienation. And it tends to be victims of abuse. When there's been abuse, maybe the children are scared or resistant to seeing the other parent. And when that happens, then they are, the other side will automatically, I don't know if that happens so much in the States, it definitely happens a lot here in Australia. And I do know people in the States that have said that they see this a lot too. But the counter argument to domestic violence, domestic abuse, as we call it over here, is very, very often it's alienation. No, it's not me having done anything to the kids. It's the other parent that has alienated them, and that's a false claim of alienation. And I guess in times like that, if it takes 2 years, those kids are safe for another 2 years, because what we're seeing happening here is that there is no education that's compulsory on domestic abuse for any legal professionals in the UK, which is utterly shocking, I think. Some, are good guys and they're out there and they want to learn, and they do their best to learn. Others have no interest or just simply don't have the time or aren't interested. And so those cases are very much overlooked. And in most cases in the UK, it's been proven by lots of research recently done by organisations like the court said, that actually that false allegation of parental alienation will trump domestic abuse in most cases. So is this something that you're seeing over there too, Joseph?
That's actually quite shocking to me, because particularly in California, that's where I am, that's my area of expertise, there is such a strong focus on protecting victims of domestic violence, to where the court system will, if anything, err on the side of caution and overprotect a person who makes a claim, at least in the early stages. So if somebody comes to the court with a request for a domestic violence restraining order, it is a very, very low threshold for them to get that, meaning they can make very minimal requests. Mind you, they still have to provide evidence down the line to substantiate their claims. But there's actually an erring on the side of caution, to where we'll grant this request for a restraining order, which oftentimes will involve protective orders for the children as well, for you to, of course, later provide that evidence to the court and show the court what has been going on in this situation. So in California, there's actually very little correlation, I would say, between claims of domestic violence and parental alienation, to where there's actually that err on the side of caution and the desire to protect a victim of domestic violence.
Wow. I mean, that's really good to hear that somewhere on the planet this is working. But I suppose the challenge can then come later down the line, because often with domestic, I mean, I know, just for listeners, like in the US you use the term domestic violence. Over here we use domestic abuse. It means the same thing. It covers emotional abuse, coercive control, financial abuse, doesn't it? Domestic violence. So
that is correct.
Yeah. If you turn up with a bruise or a burn or a broken arm, that is evidence that is very easy to see and is very easy to demonstrate. When you've been the victim of coercive control, that is much, much harder to collate evidence, especially when you're putting evidence in front of people that are not trained and don't, you can't be an expert in everything, but there's not even a requirement for specialists who are regulated and trained and vetted continuously. There's some, I would say experts in sort of quotation marks, because they're not experts, that can get pulled into these cases, who are part of the corruption I see in the system already over here. But to actually prove that as a victim of abuse, and the burden falls on you to prove it, that can be very, very difficult, can't it?
It absolutely can. So I by no means would I say that it's an easy process for somebody to do, but that's kind of why you'd want to go to your experts, such as, at least here in California, certified family law specialist attorneys that at least know and understand the factors that the court looks for. When you say broken, corrupts, it is, like I said, it is not a perfect system by any means, especially when we have, and this is again part of the broken system, typically brand new judges with no experience as judges end up in family courts. And that is their area to learn how to be a judge. They generally don't know family law. And as family law attorneys, we're often the ones educating them on what those laws are. So if I have a client who's a victim of domestic violence, I have to present the laws concerning domestic violence and quite frankly, walk the judge through it to understand what those laws are. So if it's describing coercive control, for example, and thankfully for victims of domestic violence here in California, uh, the Domestic Violence or Abuse Prevention Act here expanded and specifically defined what coercive control is. So that's involving, say, restriction of victims' movements, financial control, mental control, uh, having some form of influence over the victim to where you instill fear in them to where they feel they cannot do something they of course are legally able and entitled to do. And proving this in court can be a number of factors when you say there's no bruises. So that could involve pulling financial records to show that this person did not have access to money and they were trapped. Generally, if there's emotional abuse, that can involve abusive text messages as well that show that. So it's a matter of making sure that's presented. And it's a matter of preparing a client to articulate their message to a judge as well, because this is a court of equity. This is a court of uh, being able to present yourself, which can simply be telling your story. And a person without training walking into court when there's a courtroom full of people, a judge on a bench, it's very intimidating. But me, I have to take it upon myself, of course, to prepare the client so they understand what the expectations are and to help them tell their story. And that can include me preparing their testimony. So when I ask you questions, let's walk through this story together so they're comfortable, because
Yeah.
ultimately the client will have to tell at least portions of the story themselves to the
Yeah.
judge.
I mean, I think that's great that you do that. In the UK, lawyers aren't allowed to prep you for court. They can they give you a sort of, I don't know why that is, but they can't sort of help you get your story together. They can sort of say, be yourself, just be natural, whatever. But what I found when that was my advice given, I went into something that was far worse as someone giving evidence in the family court than any Tom Cruise movie I'd ever seen. Like the animosity and the venom from the barrister I had never experienced, apart from my ex, funnily enough. And I really felt like they'd become the mouthpiece of the abuse, and I wasn't ready for that. I wasn't ready for somebody that I didn't know. I didn't have, didn't know me to talk to me in that way and intimidate me. But obviously, since then, and having been working with thousands of people around the planet now on helping them with these kind of things, I wish my lawyer had said to me, it's going to be hell. Prepare yourself for the worst, because even if you get a barrister that doesn't do that, and I have been to court many times, and I have clients that have been to court many times, and sometimes you will get a barrister that will talk to you as a human being, maybe push certain things, maybe use certain barrister tricks to get you to speak more than you really wanted to, or to lead you down a path to something maybe you hadn't wanted to get into. But yeah, they're sort of the negotiation tactics maybe, but the aggression and the venom, like if you're not ready for that, and especially if you're vulnerable, maybe you're, overly emotional, still heartbroken, or maybe a victim of abuse that's still recovering from that, that can really disable you in the box and paralyze you. So you come across not best representing yourself. So sometimes I think it's best to tell clients, look, worst case scenario, it's going to be worse than any Tom Cruise movie you've ever seen. So prepare for that, and anything better than that, you'll fly through. I don't know what your thoughts are on that, or whether that happens that way over there, but it definitely happens over here.
I would say yes. There's a lot of there's always going to be public misperception on what happens in a courtroom, because oftentimes most people have not been to court. Their basis of what goes on in court is what they see on television, what they see in movies, And oftentimes they'll expect somewhat of an elaborate performance. And it's really about preparing somebody mentally for what will happen when they step foot in there. It's also good to have an attorney that's been before all the judges in the local area too, because for me, I will walk into certain courtrooms and I will know this judge is going to be very hostile. This judge will be unsympathetic, and I need to make sure that my client knows that. So there's not the expectation that this judge will be kind. There's not the expectation that this judge will care tremendously about me. But okay, well, this is business. We're walking in here. I need to show the judge these factors because, quite frankly, the judge just looks at me as somebody who's before me for 10 minutes and just wants to get me out the door, and will make some blanket ruling based on what he or she perceives within that period of time. So I need to make good use of that time while I'm before this individual who knows nothing about me, cares nothing about me, versus there's other ones that do genuinely care. And those are nice judges to be before, because we learn when we're before some of these judges, okay, this person really is making a meaningful attempt at learning the facts, and this judge really does want the best for this situation. And again, part of the broken system. I wish there was a way to better vet these judges too.
It's not just the judges, though, is it, Joseph? It's also the team on the other side that are questioning you in the box, right? Which could be, the barrister or the attorney on the other side who's asking you questions in a way that's designed to break you down or to trap you or to make you emotional or maybe angry.
And that is absolutely true. And again, that's kind of my job to prepare them, because I think there should at least be a expectation that the other side will be aggressive to you, but that's also your attorney's job to prepare you for all what to expect and to not get rattled. Well, nobody knows, and kind of my means of prepping somebody for that is, well, you know your spouse better than I do. What will they do to try to rattle you? Because they're probably going to tell their attorney what will upset you, what facts might get to you. So let's expect the worst from them. Now, expecting the worst from a judge is kind of the unfortunate part of the mix, but we're always going to expect bad things from the other side. But let's prepare you for that. Let's get you in the right mental state to deal with that as well. And part of it for me too, of course, is making sure when they cross the line on certain issues, which they absolutely will, then that's my job to object to storm.
Yes, absolutely. And I do think that's really good advice to prepare clients. And so for people listening, I don't want you to worry about this, because if you are finding that you are going to be going to court, preparation is the key. And what I found to my detriment was, just be yourself, you can handle this, you'll be okay. It's not enough preparation. You need to, what I call, zip up your Teflon suit, so that when you go in there, you expect, like you said, Joseph, that your ex is sort of this representative, is the mouthpiece for them. So anything that they would want you to hear to upset you is going to come out. If you expect that and it doesn't happen quite in that aggressive manner or in a way that's that upsetting, great. But if it does happen, you're not going to fall apart, because you're going to go, this is one of the tactics that I've understood is going to happen. And it's not nice, but I can still take a deep breath. I can take a sip of water, can compose myself. And I know that I've got the responses ready. I know what I'm saying. I'm going to stay true. So that gives you a better chance for best representing yourself, rather than becoming a sort of sniveling wreck who just doesn't understand what's going on, because that I've seen happen too many times. So preparation, Joseph, as you say, is really, really important. Well, I mean, I find all this really, really interesting, and I'm grateful that you're here, because this is something that is really useful, I'm sure, for a lot of people listening. Obviously, if you're going to get dragged into a court scenario, there are going to be costs, sometimes huge costs associated to that. And one of my bugbears is that it's very rare to get a fixed fee system because you really don't know what's going to come up, I guess, in a lot of ways, especially if your ex is toxic, there's going to be different curveballs that are going to be coming at you and the case can sort of take longer. But what are your tips for helping people if they're facing that to sort of save money or protect their money as much as possible when going through a court case?
So there are, well, here in California, at least, there's a number of factors that the court even looks at with regard to who pays the attorney fees. So when we talk about a victim of domestic violence, for example, we have prevailing party doctrine, which means that if you had to litigate the issue of a restraining order, you prevailed, you showed that your spouse or romantic partner was the aggressor of domestic violence, you certainly can go after them for attorney fees and costs. We have other issues there concerning, of course, income disparity. So if you are the lower earner in the marriage, it's California Family Code Section 2030. And that evaluates the income of the parties. So if you're the lower earning spouse, to equalize the playing field, essentially, meaning make sure that both spouses have equal access to representation. The higher earner is almost always going to pay the majority of the attorney fees, not only for themselves.
We don't have that over here.
But
So
for
that, as far as I know, it doesn't exist over here as far as I know. But I don't give legal advice, so I guess we're going to check that out. But what I mean is, these processes can really spiral, can't they? And you think maybe your initial cost estimate might be, a lower amount, but before you know it, you're way past that. But then you can't get off because you still haven't had your hearing and you haven't done the paperwork. So, are there any general tips that you have that can help people to cut down on what they're spending if they are going to court?
Yes, be reasonable and find a good attorney. So part of that is, and I have this discussion with clients all the time, because plenty of my clients are not seeing things clearly all the time, to where there's a lot of emotion involved, and they want to use the legal system to not necessarily punish their spouse, but they don't want to compromise. And so, for example, if we talk about financial issues, property division is very predictable, meaning there's very few occasions where I would say your results will be different by litigating or going to trial on a property division issue that we could not have otherwise predicted outside of courts. So settling these issues, of course, will limit the client's costs as well. It's really a matter of if a case gets to a level of extreme contentiousness and there is no reasonableness on either side, then legal costs are going to be very, very expensive. If they want to fight about every little issue, that drives costs up. But if
either side, but if you're you're divorcing a toxic, abusive partner, even if you want to compromise, you may not have the opportunity to, because everything you suggest that is reasonable is dismissed by the other side, though, right?
That is possible, but then that's kind of when we use the attorney fees provision in the California Family Code to tame them down. So if we have another side that's, again, so if it's somebody who's trying to over litigate or just lack of reasonableness, their attorney fees are going to be very high. And generally, it's somebody who has the ability to pay attorney fees to where they drive up legal costs. So if they're doing that, then that's kind of up to the other person who's trying to settle the case, who's trying to be reasonable, to use the tools they have. So we can employ what's called sanctions. And in California, that's Family Code Section 271, and that is based on a person's bad behavior. So
I wish
if there's
bad behaviour came into it in the UK. Bad behaviour is just ignored.
so what we look at with that is, okay, is this person over litigating the case? Are we making meaningful attempts at settling the case? Is this person filing frivolous requests with the courts? So that could be a matter of filing. So for example, if we're discussing custody, generally a case and a court has made custody decisions, generally it's going to be at least a year needs to pass before the court would even consider a modification of a child custody schedule. So if an order is made and a parent 3 months later files a custody modification, that's probably going to be a showing of bad faith. Or if a person who say it's a payor of spousal supports, and it was a very long marriage. A court enters an order, say a 30-year marriage, for example, and a court enters an order for spousal support. There's been no changes in circumstances. Both spouses are, the payor is still working the same job, the recipient still in the same position, and 6 months later, they file a request to modify. That's probably going to be a showing of bad faith and an attempt of over litigating. So when you do actions like that, you certainly can make claims for attorney fees, contributions, or sanctions based on bad faith litigation. So those are certainly ways to try to tame down someone who's behaving egregiously, who's being uncooperative, who is fighting for the sake of fighting.
I wish we had that protection over here. We definitely do not. And that, as far as I know, is not. I mean, having been through the system myself and worked with so many clients, like bad behavior, there doesn't seem to be any punishment for bad behavior. In fact, the system seems to, encourage it in a way that because it's not stopped, tactically, it's probably best to act like that because you're going to get more out of the system. So I think that, again, is where, as divorce coaches, it's really educating our clients from the emotional point of view. Just like you say, strip out the emotion, compromise where you can, and understand that if you're going to court, the costs are going to be so much higher. So when you're working out your final settlement of what you want, and, if it means compromising, make sure that you're taking into account the cost of going to court, because that could be, in some cases, tens of thousands, if not hundreds of thousands of extra costs, which actually, if you'd have settled, okay, it might have been a bit lower, but you saved yourself the financial cost of going to court, but then also years of time and years of emotional stress, which can be really debilitating as well. And also we have to remember that this is a settlement at one point in time. And you can, go on, can't you, and create a new life for yourself, new income streams, new revenues. That isn't it forever. It's it for right now, and then find other ways. Do you agree with that?
I think I do agree with that, yes, because, and I'll tell clients this all the time too, is that you have control over your settlement as well, to where it might not be perfect. You may have compromised on certain things that you did not want to. But there's a good chance the other side did too, because you guys reached that settlement based on knowing it wasn't perfectly what you wanted, but it would get this done sooner than later, cheaper than going to court as well, and allowing you not to have this hang over your head for much, much longer than it could have. Because if you go to trial in California right now, particularly Southern California, you're probably not going to get a trial date for 1 to 2 years. Yeah. And having that hang over your head for another 1 to 2 years, when say you were presented a settlement offer that was not perfect, but not necessarily horrible, it's in your best interest to try to work that out, to have that meaningful discussion and resolve that, rather than say, not going to do it. Let's set a trial date and wait for that to come.
Yeah. So, I mean, you did say earlier that, trying to find a good attorney, a good lawyer is the best way forward. I mean, I talk a lot about the dark side of family law because I see it every day. And I see that, people, that law firms weaponize difficult situations, either to increase billable hours or fees, or I do see there are good guys out there, and I work with a lot of them. I think that's great, and they're the ones that get all my referrals from my clients. But unfortunately, there is this other side, which some of the letters that I have received personally, and also I see from my clients from the other side law firms, are bullying, intimidating, and honestly, in any other profession, you would be struck off for writing such an intimidating, terrorizing letter. But yeah, it seems okay, and it's okay to do that in family law, and that's something that really doesn't sit well with me, and lots and lots of people I know for sure. So how do you go about finding someone good? I guess that's the question. How do you know whether they're someone that, because they all present as, oh, we'll look after you, don't worry, and we've got these systems, and they all present that way, but how do you tell who really are the good guys and who are the dark side?
I think a person should meet with at least 3 attorneys, at least, prior to hiring anybody. One of the most important things, I think, and I tell people this all the time, is during any initial consult I have, if you like everything this attorney you're interviewing is saying, run, run, because they are telling you what you want to hear. Oftentimes, they're setting your expectations incorrectly, or just giving you bad advice, because there is no case I have ever encountered that has perfect fact patterns, and that the law simply is on your side on every issue, because there's always going to be something that this person does not like, or some law that just will not work in their favor, whether that be an issue of financial issues or issues concerning custody that they won't like. But it's a matter of telling it to the individual straight, telling them what those likely legal outcomes will be based on their facts, and telling them what's worth fighting about and what you need to settle as well. So really, if you speak to somebody you like everything they say, probably they're not telling it to you accurately. I think it's important to also, if the attorney says, "Oh, we'll win everything, we'll go to court on all of it," also a bad sign as well. You want somebody who is oriented toward making meaningful attempts at settling the case. You want an attorney that knows other attorneys in the area, and that is not a jerk. So
not a jerk.
And a lot of people think that having an attorney that's a true so-called pit bull or bulldog, that's a good thing. You want somebody who knows how to play nice with other attorneys, because that actually does more service for their clients than not. So you want somebody who's able to work with other attorneys, make meaningful attempts at resolving the case. And for those issues that you can't resolve, that's when the bulldog comes out. That's if you have to go to court on, and say, try 1 or 2 issues of your case, that puts you in a tremendously better place than having to take every issue of your case to trial. So for example, in a lot of cases that I deal with, I'm able to settle a number of issues in these cases. Say we're able to resolve every single financial issue of the case. We're able to settle all the property division issues, spousal support, and so forth. But one issue we can't agree on is a custody schedule. We can even tailor down, okay, so we agree at least on these days being with this parent or that parent, but we have issues of this. We set issues of trial to very limited issues that we can't agree on, rather than throwing in the towel saying, "Oh, we couldn't settle anything, let's set this case for a 5-day trial."
Yeah, very, very good advice. I especially like, don't pick an attorney that's a jerk. That resonates. But I think, it's quite hard, isn't it, when you're emotional and you go and find an attorney or lawyer, and you're there, and usually you guys talk a bit of a different language, which can be quite frightening, intimidating for us lay people who don't really understand the job. And then on top of that, if you say things like, you've got one person that's saying, look, I can't guarantee, or, sometimes it could go either way, and maybe your settlement won't be quite what you're hoping. And then someone else says, oh, don't worry, we'll look after it all, and you win, and you get this, and you'll get that, and you'll be looking at X amount. Sometimes you think, oh, well, that person makes me feel better. So again, it's really good advice to point that out, that, if it's too good to be true, it usually is. And the pit bulls can be extremely expensive because they want the conflict, and that's how the letters start flying and the disagreements, trying to set the record straight and pull them back to reality. And in my experience, they can be the most expensive. And even if you don't choose one, if your ex has got one, you're probably in for a hell of a ride. So you need someone who
There can be, and it's interesting too with those cases, because I deal with that all the time as well, where I'll have a client, and then we'll see, oh, well, your spouse just retained so-and-so law firm. Mentally prepare yourself. You're going to see some angry letters. They may file several frivolous motions with the court, but that person who's hired that so-called pit bull, then when they get in the court with me, and I get their their request denied, it usually causes them to do some reevaluation down the line too. So again, oftentimes those people that hire these so-called pit bulls, it's all smoke and mirrors.
Yeah, and we have to know that it's not.
And then they go up against the other attorney who has done reasonable things, who presents themselves reasonably and eloquently in court, while their attorney's over there screaming up a storm, and that attorney gets what their request is denied. They kind of learn after that too. I always compare it to. Okay, so if you're in the grocery store with your child, and your child says, I want, this candy, you say no, and they scream, make a scene, throw a tantrum. Does that make you want to buy your children that candy? Chances are no. So the same result goes in court. So if your attorney's coming off in this highly aggressive manner, that is very disrespectful generally, that is very just poor behavior, that's not going to get the client the result they want either.
Well, let's hope so. In the whole, I've seen judges respond both ways to that, and it's distressing for all involved, I would say. So yes, don't worry if you're up against them. If you've got one of the good guys, they can hold their ground, fight your case, and keep you safe. That's the goal. Joseph, you shared so much amazing advice with us today. How do people find you if they want to find out more about you and the work you do? Where can people find you?
So my website is willmorelawfirm.com. That is with 2 L's. I am on Instagram as well, TikTok. We can certainly provide all those handle informations below to reach out to me, based in, of course, San Diego, California. For any listeners that are in the region that wish to reach out, they're more than welcome to reach us online or by phone.
Brilliant. Well, thank you so much. It's been fascinating, and you're very brave to have joined me. I appreciate that. But I've really enjoyed our chat, and you've definitely shone a light on some of the good work that you do. So appreciate that.
Sarah, it was my pleasure.
That's it for today's episode. Do head on over to willmorelawfirm.com to find out more about Joseph and the work he does. And I look forward to you joining me on my next episode.
That's it for today's episode of Heartbreak to Happiness. Don't forget to subscribe and leave a review to win a free ticket to Sara's virtual Heartbreak to Happiness retreat. This is a transformative combination of live webinars with Sara herself, coupled with her empowering online video program designed to help you cope better with your breakup and start feeling happy again. For more details, head on over to heartbreaktohappinesspodcast.com, where you can also get a copy of Sara's gift. Thank you, and join us again on the next episode for another dose of Heartbreak to Happiness.